2. The session 2 in your workshop materials is titled Enforcement and the Courts. And we have a new panel with Tel Karp. Sitting next to Tel is Magistrate David Fanning. Next to David is Brendan Lakota. Next to Brendan is Sergeant Jane Baldwin. Next to Jane is Susan Dobson, who sat on the previous panel, and Sam too, who's the acting manager of the Infringements Court. So, ladies and gentlemen, a case study for John that's in your materials, where he recently had a knock on the door from the sheriff, serving him with a 7-day notice. John comes to us with a 7-day notice and also brings in a parking fine he got a week ago. Brendan, can I start with you? Sure. What are John's options with dealing with a 7-day notice?
Well, the most important thing with the 7-day notice is it's a 7-day notice, so he has to act quickly. And his options change depending on what's happened in the past as well. But by and large, most infringement court options are still open to him right at the start of when he receives that 7-day notice. So he can still apply for a revocation. Issues can arise, though, if he's already received a notice of intention to suspend the driver's licence or registrations. So that's where we can get some issues. But by and large, the options are exactly the same as long as you're acting before that 7-day notice expires.
Jane, what happens when you give somebody a 7-day notice, and in what circumstances would you ask someone to... We've had some situations where people have advised us that they've been asked to waive their 7-day notice.
Okay. Upon our first attendance at it could be a residential premises, it could be High Point Shopping Centre, for example. If we do make contact with the defendant, we obviously make a payment demand. Part of that process is also serving that person with a 7-day notice. We explain to them that they have 3 options. One is to pay in full the amount outstanding on the notice. 2 is to apply to the Infringements Court for an application of time to pay. Or thirdly, they do have the option of submitting a revocation again to the Infringements Court. Also at that time, sanctions can be applied by the Sheriff's Officer if the outstanding amount isn't paid in full. Consent to waive 7-day notice, Gary, is only applicable at the point of arrest. So we may be holding, for example, 10 warrants against the defendant, one of which may have been previously served a 7-day notice. So at the time of arrest or the second call, the defendant does have the option to consent to waive his legal rights on the remaining 9 warrants, so that execution can continue and we can proceed along with arrest, bail, etc.
And can you outline some of the powers that you have, please, Jane?
If the attendance is at a residential address, at that first call, when we're in the discussions with the defendant, serving him the required notice, we would more than likely also provide him with a copy of the outstanding fines. The officer will ask for peaceful entry inside the premises to ascertain whether or not that person has any seizable assets that can be levied against the debt. In the event that assets are identified, those goods would more than likely be seized in walking possession, as long as the defendant is willing to sign the safekeeping provisions of the seizure. When we talk about assets, we have to operate within the Bankruptcy Act provisions, so they're indexed figures in reference to motor vehicle values. Household items are also covered, along with tools of trade. If there are no seizable assets, then at that first point of call, we can issue a notice of intention to suspend the defendant's driver's licence and/or any vehicles that are currently registered to them. We can also apply a wheel clamp to a vehicle that is currently registered to the person.
So if you apply a wheel clamp, does the provisions of the Bankruptcy Act apply to that vehicle?
No. No Bankruptcy Act provisions apply when we talk about wheel clamping. So the vehicle can be worth, for example, $2,000, and we only need one outstanding warrant to enable us to wheel clamp that motor vehicle. The other thing is that it is irrelevant at that point as to whether or not the vehicle is currently subjected to any type of financial encumbrance. Again, the vehicle can still be wheel clamped.
And what happens then once the vehicle's been wheel clamped?
When the vehicle's been wheel clamped, again, we'll be urging that the defendant contacts the infringements court if they're not in a position to pay the matters in full at that point, to obviously try and resolve the matters through an instalment payment plan or submitting revocation, etc. If that doesn't happen, then generally speaking, we would allow the defendant anywhere up to a period of 7 days. It can happen prior to that, but the vehicle would subsequently be detained.
In the case where someone has a vehicle worth $2,000 and they may have no other income apart from a Centrelink benefit, what advantage why would you wheel clamp in that situation? Or what other alternatives would you offer to the person with the infringements other than wheel clamping?
Our main role is to enforce compliance within the community. So again, we'll be highly emphasising that it's in the defendant's best interests to actually contact the infringements court to resolve the outstanding matters by way of payment plan.
So with the wheel clamping and revocations, once the car has its wheel clamped, that clamp won't be removed until the revocation application is actually heard and accepted. So if you are in a situation where one of your clients desperately needs their wheel unclamped, there have been situations in the past where an urgent application for revocation can be sent along to the infringements court, and even if that application is refused and a court referral issued, then once that's referred to court, then the wheel clamp can also be removed.
Is there a cost involved at that point?
No.
No, there's not. So I think the key with what Brendan's just touched on is, in the event that you do submit revocation to the infringements court, if that application is subsequently refused, the wheel clamp will remain on the car. So the simple lodging of the application doesn't allow for us to remove the wheel clamp from the vehicle at that point in time. So at any stage when we're dealing with a defendant, if there's indication that they wish to submit a revocation or there's special circumstances, we strongly suggest that they personally attend civic compliance and speak directly to one of the court registrars at civic compliance.
But the sheriff has the option of offering a community work permit or a payment order when dealing with somebody, when executing a warrant. Can you tell us about that?
That's correct, Gary, but what we need to understand is that we have a hierarchy of execution, so we're governed by legislative requirements when it comes to execution of infringement warrants. So before we can actually look at offering a defendant a community work permit, we have to ensure that there are no seizable assets, because if there are assets identifiable, then we're obligated under the legislative requirements to seize those assets. So we have to exhaust all of those avenues first before we get to the stage of arrest. So community work permit, we have to physically arrest the defendant in order to sign them up and get their agreements to perform a community work permit.
Can you tell us what some of the guidelines might be for you to be able to organise a payment order at the time with the client? Can you organise a payment order with the client, and what are the guidelines around that?
We can organise a payment plan directly with the defendant as long as the defendant is eligible for the payment plan. So there are a number of checks that the officer will conduct prior to engaging with the defendant. So we'll be looking at the total indebtedness outstanding. So that's not just the active warrants that we may be holding, but also any enforcement orders that are identified. So we look at the total indebtedness. As Sam touched on previously, if that amount exceeds $10,000, then automatically that prevents us from proceeding any further with a payment plan. We also consider payment plan defaults. So again, if there's in excess of 4 defaults, then that prevents us from entertaining a payment plan. If any of those conditions are present, then generally speaking, we will refer the defendant back to the infringements court.
Brendan, can I ask you, what are the different kinds of warrants that we might see in our practice, and what's the danger of, for instance, a warrant to imprison?
So one of the things that we touched on at the start was getting the right information and making sure that you knew exactly what was out there for your client. And this is particularly concerning around warrants. You need to be careful that there are only infringement warrants outstanding. If there are any warrants to arrest, then you run the risk of your client immediately being arrested. And if it's a warrant to arrest under a Section 160 imprisonment in lieu, which we'll talk about later, then they could end up being sent immediately to prison. So we just need to make sure that right at the start that you do know whether or not you're dealing with infringement warrants or warrants to arrest, because it's a key difference and can completely change the way that you'll approach a case.
One of the things I'd just say is that one of the aims of the Fines Reform Bill is to sort of truncate that infringement life cycle and to bring everything in. And part of the way that we're going to do that is by having director-based sanctions. So when something has been submitted to us for a notice of final demand, which replaces our existing enforcement orders, the director will actually be able to send out automated sanctions. The hope there is that people are able to sort of intervene with their matters prior to them even getting to warrants and prior to the sheriff having to go out and serve the 7-day notice. The idea is that the Director of Fines Victoria has a range of powers, and part of that is about being able to deal with matters as early as possible. So when the notice for final demand goes out, which is, as I've said, the equivalent of your enforcement order, you're going to receive all of the potential things that might happen as part of that document. So you'll be told that you could receive an automated license sanction, for instance, and that sort of information will be provided up front, and the shorter timeframes also we're hoping will lead to people responding more promptly.
Gary, if I may just elaborate on the process of whereby you have a client that has outstanding infringement warrants together with a warrant to imprison. The process of our execution changes considerably when those two warrant types come together. So the warrant to imprison takes priority. So if there's any form of payment that's being offered, that payment in full must be allocated to the warrant of imprisonment, not the infringement warrants. The other important thing to consider is it is automatic imprisonment, so that the person would be arrested and immediately conveyed to a prison or watch house. Those warrants are executed in conjunction with the infringement warrants at that point in time. So even if the person does have seizable assets that are identifiable at the time, or a motor vehicle that could be wheel clamped, we will not proceed down that path. So the person would be conveyed and lodged, and where practicable, the police would take the defendant before the magistrate within a 48-hour period to appear on the infringement warrants.
What is the proposed timeline for the reforms?
The whole fines reform package is very complicated, and obviously it doesn't just involve policy and legislative reforms, but it involves a whole heap of system changes, business process changes, and organisational changes. This takes a lot of time. We recognise that a lot of our key stakeholders will also need to do system changes and business process changes. With that in mind, I'm not privy to all of the conversations that might be happening around this issue, but I know that the department is very concerned and conscious of the transitional period and the transitional period for our key stakeholders. And as soon as they are able to provide some definitive advice to key stakeholders, they will, to give people plenty of time to transition to the new arrangements. In the current legislation for fines reform, there is a default commencement date of 30 June 2016. Any changes to that default commencement date will be the subject, or potentially could be the subject, of a legislative bid, which is obviously subject to parliamentary processes.
Okay, now we move on to the second section, which is the penalty enforcement warrant, or sometimes referred to as PEW, and Section 160 hearings. What is a penalty enforcement warrant hearing, and what submissions should be made at a Section 160 hearing?
So if a person has unpaid warrants that haven't been dealt with through earlier processes that you've heard about today, a person will be arrested and bailed to appear before the magistrate's court. It's called a Section 160 hearing because the powers that the magistrate has are pursuant to Section 160 of the Infringements Act. Ultimately, Section 160 sets out a bit of an arithmetic formula. It says a person is to be imprisoned for 1 day for every penalty unit that is outstanding, and a penalty unit at the moment is about $150. Under that section, it also sets out some tests that can be satisfied. So if the person has special circumstances, or if imprisonment for 1 day for every penalty unit would be excessive, disproportionate or unduly harsh, that's the test set out in the legislation, the magistrate is empowered to discharge the fines in full or in part, or to impose a community work order. So in terms of what submissions to be making at a Section 160 hearing, it really depends on the circumstances of your client. Certainly at Legal Aid, the people that we see have a complexity of circumstances, and we've heard about them a little earlier today. I find that in my practice, it's much better to use Section 160 subsection 3, and that is the test of excessive, disproportionate and unduly harsh. And I refer you to pages 14 to 15 of the practice resources for a bit more detail about that. But the reason I often use that test is because it can be a bit of a one-stop shop for all of the issues that the client is facing. You heard that one of the weaknesses for the special circumstances test referred to earlier is that you need to establish a nexus between that circumstance and the offending behaviour. You don't necessarily need to do that with the test of excessive, disproportionate and unduly harsh. What you need to do is say why this person might be less culpable than another because of their mental health issues, why imprisonment for that arithmetic formula might be unduly harsh because the person has 2 small children at home and they're the sole carer. So depending on the nature of the person's circumstances, you can put those to the court under that provision, and it's also really helpful to say how the circumstances might have changed now. So the client is getting their life back on track, and I find that in submissions it's really important to put someone's financial circumstances and evidence to that fact so that a magistrate can be more sure that their life is changing.
So is that a point that a financial counsellor can assist with?
Financial counsellors, I'm finding, are incredibly helpful at this part of the process because, and you've heard the word used a number of times already, imprisonment in lieu orders are orders of imprisonment where, pending the ability to make payments on an instalment order, if a person fails to make a payment, the person goes straight to jail. So in determining what imprisonment in lieu order is set out, so what instalment order is made, financial counsellors can be really helpful. We need to know how much a person can pay per month. We need to know when that person can pay. I find that magistrates are increasingly requiring a financial statement to be tendered before the court. So I find that financial counsellors are incredibly helpful at that point, noting that the outcome, if they fail to comply with an instalment order, is jail. It's really important to make sure that they're connected. And I should note, previously I was talking about Section 160 providing an arithmetic formula for imprisonment. Typically what happens is that someone isn't sent straight to jail, but they're put on an in lieu order, an imprisonment in lieu order, so that they don't go straight to jail, but provided they pay $100 a month for the period of the order, they stay out of jail. The problem is when they can't pay, when circumstances change. And the fact that they go straight to jail means that sometimes we don't get to see them as legal practitioners.
Are you saying that in one of these hearings there is no other option other than imprisonment in lieu if there is a financial penalty imposed?
No, there are other options, and I'm sure Mr Fanning can also speak to some of those. So under the Section 160 subsection 3, I'm sorry, I shouldn't use legislative provisions, the disproportionate limb that I was telling you about before, there is an option to do community work, and that sometimes is better for our clients. But where someone is likely to breach their imprisonment in lieu order, sometimes you can ask the court to impose an adjournment. So over the period of 6 months, the magistrate might say, look, if you can pay as a voluntary amount, and it's probably not the right terminology to use, but we do call them voluntary instalment orders often, if the person can commit to paying, say, $50 a month and staying out of trouble and connecting with a mental health counsellor, then at the end of that 6-month period, the magistrate might determine to discharge more than they would have otherwise, or they would have taken into account that compliance. So sometimes an adjournment can be a more useful option, but there is a risk because the person is on bail. So if they are likely to commit further offences, you do have the issue of offences on bail.
What Tal says is somewhat understated in the sense that the person's personal circumstances, that is, as to what has changed since the offences were committed, is highly relevant. I don't think I'm alone in taking the view that it's quite significant to learn and hear about the personal circumstances when they committed the offences to their circumstances now. That is, that what happened 2 years ago and 3 years ago, and often is some years ago, is different from their current circumstances because they've been working with their drug and alcohol counsellor or their financial counsellor or other persons who have been able to assist the person to ameliorate, change, have a different life. So I can't overemphasise the importance of, when looking at the offender's situation, which is what the legislation says, that you're looking at both at the time of the offending and their current situation. That's crucially important. So magistrates, by and large, I can't speak for everybody, but by and large, are reluctant to do that in the first instance unless they're reasonably confident that the person's going to be able to comply with the order, and hence the value of the adjournments. The other aspect I'd say is that magistrates are in fact under a legal obligation now, since a case, and it was called Tahir, some years ago, whereby the Court of Appeal said that magistrates or the court must inquire about a person's circumstances. So it's not a discretionary thing that magistrates should be doing or can do. They're in fact under an obligation to do it. And hence we've seen across the board magistrates being, perhaps some of those who weren't as interested are now more interested in hearing about person's circumstances, and part of that is financial counselling. In writing the reports, firstly that the reports be honest, that they be frank, and that they be clear. They're really important components. Nothing is more frustrating than reading a report that is hard to understand, or that's jumbled, or that doesn't seem to cover all the aspects of a person's financial circumstances. So take a bit of time to make it clear. Talk to your colleagues about, if you haven't done one before, about what's good in a report, that is what has worked well, and give it to somebody else to read so that it makes sense to them, not just makes sense to you. You know, magistrates have tens of cases that they're hearing a day, could be 60 cases easily in a list. It's a constant pressure to get through matters, so the clearer that you can make it, the more accessible and readily understood, the better it is, and the better you will be as an advocate for your client.
One of the changes we've seen recently is financial counsellors being in court or based at a court. David has the benefits that there are financial counsellors based at the NJC and now in the special circumstances list. And so financial counsellors have the opportunity to provide the court with an insight that otherwise they wouldn't have, not only on their financial situation, but their personal circumstances.
It's similar with the special circumstances revocation applications in that you need that evidence. So whether it be while you don't have to, as Tal and Mr. Fanning have spoken about, you don't have that nexus requirement, and typically we're talking about the subsection 3, excessive and disproportionate provisions. the evidence is what you can bring to make your submission on that point, and how you can actually succeed on making that point. So having a good relationship with the client where you're able to get the instructions that you need can be really important. If you're a community legal centre lawyer and you're only able to see the client very briefly, often there'll be other caseworkers, financial counsellors or drug and alcohol workers who will have been able to spend a longer time with that person. So even if you're not making a special circumstances application and you're using the excessive provision, sometimes getting those reports can help your submissions immensely, because it'll allow you to understand the person's circumstances and be able to put those before the court.
More and more magistrates are requiring you to have evidence to back up your submissions. So often, if I don't have materials to rely on and I'm just making submissions from the table, a magistrate might even ask me to go back and find that material. So it's really important to have it. That said, it can be really hard to get, particularly in circumstances of domestic violence, or where we're talking about it being disproportionate to have the imprisonment order that I was talking about before, because the client wasn't actually driving, it was somebody else, or she was escaping domestic violence, or he was homeless and doesn't have any way of substantiating it. Sometimes in those cases, you can put together an affidavit, or you can call evidence from your client during the course of the hearing, but that is really an issue that we're increasingly facing if magistrates are not prepared to accept that evidence.
So, Tal, what options do we have when someone can't keep up with these instalments, or have gone off the track, relapsed into another episode of mental illness or drug addiction? How can we help these people?
So after the case of Taha, which Magistrate Fanning referred to earlier, there have been some changes to the Infringements Act. And if somebody loses their job or has a new issue that arises after an instalment order is made, an application can be made to vary their order. And there's a form in your booklet that you'll need to file with court. I think it's on page 45 of your workshop materials, and there's some information about it at page 15. What you need to prove is that there is a material change of circumstances that requires a different order to be made, or that matters weren't properly put. Unfortunately, with the variation applications, you don't change the underlying amount that's owed, only the structure in which it is paid. So, for example, if someone is on $100 a week payment, which I'd advise against, because at the moment that means you have to turn up to court each week and pay in advance of that, you could change that to $50 a month if that's all that person could pay at that particular time, or delay the next payment. So that's one option. Another option, if a person didn't have anything discharged at their Section 160 hearing, is to ask for a rehearing of the matter. And that's under a different provision, and there's a different form for that. And that's under Section 160 subsection B at page 46 of your materials. It's really important to know that you can only ask for a rehearing if nothing was discharged at the original Section 160 hearing, which is a bit of a flaw, I think, in the current legislation, and it isn't really fixed by the new suggested amendments. So, for example, I had a query about a client who had an instalment order amount and then was involved in a car accident and became a paraplegic and couldn't pay the amount per month that was required. Unfortunately, that client... You say unfortunately, that person had 1/3 of their amount discharged at the first hearing, which meant that we couldn't do a rehearing for that client. All that could be done was to restructure the amount that client had to pay per month to a very small notional fee, but it meant that they had an order that would exist for 20 or 30 years into the future, which is really difficult with our vulnerable clients to think that they have to comply with these sorts of orders for such an inordinate amount of time.
As far as instalments, it's worthwhile asking the court, and I do it myself regularly, regarding the start of the instalment order, to argue that, or to request that it be put off for a month so that the person can get a month ahead. Because you don't want people who are dwelling on every month to be perfect, or to be able to make that, assume it's a monthly payment, to be able to always make it, because as you're aware, if you slip behind one day, then it's all over. So you want to put people in the best position to be able to make the payments. So ask for, in a sense, an additional month before the instalment starts, and say that the person commits to making the payment, commencing whenever it is in 2 weeks' time, but to actually have it on the court record is starting the month after that. So they're always going to be a month in advance. It's a small thing, but it really helps a lot of people to get ahead.
I'd reiterate the absolute importance of that, because life happens and someone forgets to go to court on a particular day or can't get the transport in there, and we would find a lot more people would breach their orders if they weren't a month or even 2 months ahead. The other thing in terms of structuring payments is finding out when they're going to receive their Centrelink payments and trying to structure the date of payment to be just after that, so they actually have money at the time. Things like that are much more useful to consider.
So with an application to vary an instalment order, can anyone fill that out? And what happens to that? Is it an administrative process, or is it heard before a court again?
It is heard before the court, and I'll just take you to page 45 of the materials. The application requires you to really indicate the grounds for making the application in terms of why your circumstances have materially altered and so you can't comply with the order, or if the circumstances are wrongly stated at the previous hearing. So you'll fill out this application, it will get filed with the court, and then you'll end up being listed before a magistrate.
Brendan, how important when clients come to us is it to find out whether they have these instalment orders or have previously appeared in court?
I think that all comes back to that getting the right information part that we were talking about right at the start. If you're finding out about your client's circumstances and about their fines and about their warrants and about whether there's infringement warrants or warrants to imprison, it's equally important to find out about what their instalment orders are and how they got those instalment orders, because sometimes the client will say, oh, I pay this amount for some fines, but those instructions often won't go far enough, and you will have to do a little bit of digging, possibly contacting the court to find out exactly what those instalment orders are for and how they were made, because there may have been an imprisonment in lieu order made with those. So it's very important that we know about those before we make any decisions about what to do with their remaining fines.
It seems pretty archaic that clients have to make payments by appearing at a court, especially when they're on a Centrelink benefit, and the only time they can make payments is on a fortnight that they get paid. It's very easy for people to forget having to appear at a court every fortnight. What are there reforms that are going to make it easier for people to pay by Centrepay? We don't have court fines payable by Centrepay at the moment. I think BPay has only just been brought in some circumstances. Can you tell us a little bit about the reforms and how clients with outstanding court fines can better manage their penalties so that they don't do breaches?
Mm-hmm. It's difficult for us to comment on the practices of Court Services Victoria, but I can talk about what's going to happen under the Fines Reform Act. So presently you can apply for a payment plan at the infringement stage, you can apply for a payment order at the enforcement order and warrant stage, and then there's also plans that can be established through the courts. And those are the ones we've been discussing in this second panel. The intent of the Fines Reform Act is that there'll be a payment arrangements model, and that means that there'll be one model that is sort of the person's total indebtedness across those three areas. So it's our hope that all of that sort of payment arrangement activity is rolled into one plan that's managed by us at Fines Victoria.
It is a significant benefit of the new reforms. We find that clients don't just have infringement-related matters to deal with, they have a lot of court fines as well. So those were the fines that I think Damien was referring to that start with a charge sheet and you proceed through the court and you end up with an outcome. So putting them all together is going to be a lot easier for our clients. We find that clients sometimes breach their imprisonment orders because they thought they were paying that order, but they were actually paying their court fines at the time. So bringing those things together should lead to a lot of better outcomes, I suppose, for our more disadvantaged people.
What other agencies might we be able to include in these payments? For instance, will Public Transport Victoria fines that are still with Public Transport Victoria be able to be included in these payment arrangements?
Yeah, so the payment arrangements system is designed to capture things at the infringement stage. So even if they're not necessarily something that would be listed with the infringements court or made into an enforcement order in the present world, the expectation is that they should be rolled into one, and Fines Victoria should be the central body that coordinates and manages those.
Will that include councils?
Yes.
Oh, wonderful.
I didn't mention earlier, but in making submissions at a 160 hearing, it's not just about the personal circumstances of the client at the time of the offending and now. You can also make submissions about the type of the offending, because in most magistrates' minds, there is a big difference between hundreds of toll offences, which are really about public amenity, versus public safety offences of speeding, holding a mobile phone and so forth. So you've really got to consider the seriousness of the offence as well as the seriousness of the offender's actions.
In law, there's no real difference, but in reality, what Tal says is in fact correct. That doesn't mean that the toll offences are not treated seriously, but certainly in the mind of, I would say, almost all magistrates in the state, there is a difference of view as to how, they're viewed differently. I mean, it's a truism, but it's correct that the more information, the better, and don't hold back on being frank. If you do go to court with your client, don't be, my goodness, don't ask me any questions. Whatever you do, I'll just sit here in the back of the court and here's my report. Don't ask me a question. If in fact you are asked a question, it's really because the magistrate is interested to know. It's really trying to better understand, as I say, what's contained in your report. So in fact you should be pleased and be welcoming of questions that a magistrate might ask you, because it gives you then the opportunity to expand upon and to really address the issues that are on the mind of a magistrate.
I'd like to ask, calling in warrants. Now we know that this provision was changed recently, but what's the current situation if somebody is in prison and has outstanding infringements?
Well, correct me if I'm wrong, but it hasn't changed quite yet. So you can still make the application to the sheriff to call in the warrants. It's a bit of an odd situation. If anyone hasn't done it before, you're actually asking the sheriff to call in the warrants. You're not making the application yourself, or for your client, they're not making the application themselves. That's still available at the moment under the current Reform Act, which I imagine Susan will have a comment on momentarily. That is due to change, but we've been making a lot of submissions to make sure that stays the way that it is.
Just be careful what you're calling in. So if they're infringement warrants, great, because you can have them served at the same time as other matters that you're in jail for, that is non-fine related matters. So if you're in jail for a drug trafficking offence and you call in your infringement warrants, to the extent that that could fit within the same period of time, you can serve them at the same time. But if you're calling in your court fines, the magistrate has a discretion to have them served on top of what you're currently serving. So if you're in there for 12 months already and you are calling in court fines, you might end up serving another 6 months on top of that, and you might have been better having the matters dealt with by the court through the procedures that are contained in the Sentencing Act.
Thank you. Susan, would you like to elaborate?
Sure. Brendan was right. Under the Fines Reform Act, the provisions about calling in warrants is to be repealed. We note that that was a decision of the previous government, and we have heard the cries from the stakeholders about this issue and how important it is to the stakeholders. We have briefed on this, and more to come.
As Susan mentioned earlier, at the moment the commencement date is 30 June of next year. In terms of whether things might be rolled out ahead of time or after that, that's all sort of subject to review at the moment, so not something that we can comment on. What I would say is that and some of you may have already been a part of this, is we're really actively trying to take a co-design approach with this legislative reform. So for programs like the Work and Development Permit, we're actively dealing and engaging with the groups of people that we think are going to become the sponsors in that system, because they're able to provide us the best insight in terms of processes and engagement with us as the department. So what I would say is, as soon as we know information, we'll relay that through these sorts of networks. But at this point in time, regrettably, we don't have all of the information at hand. And I suspect, if we'd had this forum in 6 or 9 months' time, we'd actually be able to provide you with a range of additional information, which would be really valuable.
I did just want to add one comment back on the calling in provisions as well. When you're working out the time the time required to be served for calling in those infringement warrants, as well as what Tal has said, and I can't reiterate that enough to make sure that you are calling in the right warrants. You also need to make sure that the time left to serve doesn't exceeds the amount of the infringement warrants you're trying to call in, or else your client will end up needing to serve extra time. And it's a simple arithmetic formula of 1 penalty unit per day.
Jane, would you like to make any comments about how we can better help our clients when you're executing warrants?
The only thing that we consistently come across in the field dealing with defendants is the critical element around our time frames. So, as I think Brendan touched on before, 7 days is 7 days. Generally speaking, unless there's other operational requirements, you could expect that we will make that call back probably on about the 8th day at the earliest, extending out to a couple of weeks. So whilst I appreciate it takes a fair amount of time for you to organise medical reports, etc., it's really critical that we do get the communication starting to roll with the infringements court. The only other thing that we've come across in the field is when we have clamped a person's car, or we're talking about arrest, they reach out to local services, and their appointment times that they're being given are 2 to 3, 4 weeks down the track. That doesn't help us a great deal, and it certainly doesn't help them. So I don't know whether there's something that can be done at your end to actually extract some more information from these people as to where they're at, what stage they're at with the sheriff, have notices been served, etc.
That brings up an interesting point, Jane. Do sheriffs check the database before they execute warrants to see if we have submitted applications for special circumstances? Because sometimes it takes a while from us submitting it to it being processed. So maybe Sam could also explain what that process is as well.
As I touched on earlier, prior to any engagement with the defendant, we actually conduct a status check, which is checking the text history on our database. So once any form of application's been made, or any form of communication, telephone or written, that is all documented on our system, so the officers have the insight into knowing what has occurred.
So when we receive an application and there's an active sanction, we prioritise those. They're dealt with urgently, so typically we respond to those within 2 working days of receiving them, which is obviously significantly quicker than some of the other processes that we're sort of undertaking. We will also engage with the sheriffs and notify them once a decision's been made. So there's sort of a bit of a dialogue going on back and forth between us and the sheriffs in the field, so that everyone's across the information to the best of our ability. Sometimes they can sort of slip through the net, and when that happens, we try and respond to those as quickly as possible.
I'm going to go back to something earlier that was said, and we keep talking about imprisonment in lieu orders as being really bad, and yes, there are significant risks, but one thing you need to be aware of is that if you go down the Section 160 route and end up with an imprisonment in lieu order, your client doesn't have a record for it. There is no plea of guilty. At earlier stages of the process, a client has to plead guilty, and there is a court outcome that results. So for some clients, the Section 160 process may in fact be preferable. So that's just something that I'd like to leave you with, and hopefully we can see some changes in that, because clearly it seems unfair for our very disadvantaged people to have extensive records for toll offences. The other point I wanted to make is in respect of rehearing and variation applications. One thing you need to be aware of is whether or not the client is still complying with their instalment order, or in fact if they've already breached it. If they've already breached their order, there is another application you're probably going to have to make, and I'll refer you back to your materials. I won't go into it in any detail, but sometimes you need to apply to have the imprisonment warrant recalled and cancelled to get the client back on its original order. If you're asking for a rehearing, there are bail provisions in the Infringements Act that you can use, but if you're applying for variation, you're going to have to seek a recall application. I won't take that further.
David, would you like to add anything further to that?
Only perhaps, particularly for the lawyers amongst you, that in regard to 160, you don't have to make a choice between whether or not you're relying on 162 or 163. You can put the arguments really in the alternative, or indeed use them together. If you're familiar with 160, you'll understand what I'm saying. Some people would take the view that they've got to make a choice as to on what grounds they're making the application. You're not obliged to do that. You'd agree with that, wouldn't you, Tom?
I think that most magistrates are very happy with you just making submissions on all of the relevant grounds. Fortunately, after Taha, magistrates are required to consider the later sections as a series of options that temper the ability to make an imprisonment order. So most magistrates, I think, are of that view. Some require you to decide which limit you're going under, and my view in respect of that is subsection 3 allows more things to be canvassed, including the things in subsection 2.
That allows for some flexibility, doesn't it?
Sometimes I'd be hesitant in trying to get matters that are dealt with at the 160 list taken elsewhere, and in fact, legislatively, there might be problems with that. It's not actually capable of doing, I don't think you're actually capable of doing that because you've passed that point. But the materials that you could use at the special circumstances list can be used in your 160 application. And remember, the outcome of your 160 application is that there is no finding of guilt. So if you have excellent circumstances demonstrable by your evidence, it may be that you just get all of those matters discharged. In my understanding, it's past the point of being referred back to the revocation process.
So, thank you all very much for attending. As I said at the very start, this is a real indication of how important this work is for us. I'd like you to thank our panellists again. I'd like to thank members of the Infringement Working Group who made today possible. And if any of you are thinking, gee, I'd like to be a member of that group, come and see us up the front. Thank you very much. Thank you.